You found Ask Alice, the podcast that takes a deep dive into the societal currents shaping our lives. I'm your host, Alice, and together we'll explore the often unseen forces at play. We'll examine cutting-edge research, dissect the data, and most importantly, if you're seeking to understand what's shaping our society, this is the place.
Okay, let's unpack this. Today, we're taking a deep dive into a question that sounds simple, but really isn't. Can you legally sunbathe nude in your own backyard in South Carolina?
Yeah, it's surprisingly tricky. There's no single law saying yes or no.
Right. So we've been digging into the sources, and it seems we need to look at broader public decency laws, specifically South Carolina Code, Section 1615-130, the indecent exposure law.
Exactly. And our goal here is to figure out what the sources say about that balance, between your privacy on your property and the state's interest in, public order.
So let's start with the actual text of the law. That's SC Code Section 1615-130A1. What does it actually say?
Okay. It prohibits someone from, quote, willfully, maliciously, and indecently exposing his person in a public place, on property of others, or to the view of any person on a street or highway.
Willfully, maliciously, and indecently. And notice that key word connecting the locations. Or.
That or is crucial. But let's break down that first part. Willfully, maliciously, and indecently. This really gets at the intent behind it.
Okay. So willfully is just intentionally.
Right. You meant to do it. Maliciously, though, that implies some kind of ill will, maybe intending to annoy or offend people.
And indecently. That relates to common standards, I guess. What society finds offensive.
Precisely. So if you're just, sunbathing privately for your own comfort and you have zero intention of being seen or bothering anyone,
then hitting those maliciously and indecently marks becomes harder for the prosecution, right?
Much harder. In fact, the South Carolina Attorney General actually weighed in on this. Their opinion basically says the law targets willful and malicious public exposure, not just nudity itself.
So it's different from someone intentionally flashing someone.
Oh, absolutely. That kind of behavior or exposure for sexual reasons, that's clearly what the law is aimed at stopping. Private sunbathing is a different category if the intent is purely personal.
Got it. So intent is huge. What about the location part? Is your own backyard considered a public place?
Generally, no. The sources are pretty clear on that. Your private backyard usually doesn't count as a public place under this statute.
Okay, that seems straightforward enough. But you mentioned that or earlier.
Ah, yes. The catch.
Because the law also says on property of others or to the view of any person on a street or highway.
Exactly. So even in your own yard, if you can be seen from your neighbor's property, their yard, their second-story window, whatever, or by someone on the street,
then the law could still apply, even though you're on your own property.
It absolutely could. This makes effective visual privacy, essential, non-negotiable, really.
So even if you meant for it to be private, if your fence isn't tall enough or has gaps and someone accidentally sees you,
you could still potentially face issues. It hinges on whether you took sufficient steps to ensure privacy.
Wow. Okay. So let's talk risks. If someone does see you, maybe a neighbor complains, what happens then?
Well, it's classified as a misdemeanor, which sounds maybe not that serious, but the potential penalties include fines or even prison time, up to 3 years.
3 years? Even for a first offense?
That's what the statute allows, yes. But here's something else the sources mention that's frankly quite serious.
What's that?
In certain extreme circumstances, there's the possibility of having to register as a sex offender.
Whoa. Okay. What qualifies as extreme?
Things like exposure, specifically in front of a child, or if the act is done in a way the court considers particularly depraved.
So the risk goes way, way up if kids might see.
Dramatically. Any chance of minors viewing the nudity changes the entire risk calculation. It becomes much more serious.
Is there anything less serious, like disorderly conduct, maybe?
It's possible, but probably less likely for just quiet sunbathing unless you're also being loud or disruptive. But it depends on the specifics and local rules, too.
Okay, so pulling this all together, what's the practical advice for someone listening who's thinking about this in South Carolina?
It really comes down to what we've been discussing. Priority number 1, total visual privacy.
Meaning tall fences, thick hedges, covering all the angles.
Every single angle. From neighbors' windows, especially upper floors, from the street, any possible viewpoint. And critically, ensuring zero possibility of minors seeing you.
Keep a low profile, too, I imagine.
Definitely. Avoid anything that could possibly be interpreted as lewd or provocative. Just be discreet.
And if, despite your best efforts, someone confronts you or the police show up,
stay calm. But the strong advice is, don't make statements to the police without talking to a lawyer first.
So basically, if you can't guarantee 100% privacy, especially from kids, or if anyone complains,
Get legal advice. Seriously, it's the safest way to understand your specific situation and risks.
So wrapping this up, what's the bottom line here?
The bottom line is, nude sunbathing in your SC backyard isn't illegal per se, but its legality is completely dependent on you ensuring total visual privacy and having purely personal, non-offensive intent.
It's all about that balance the law tries to strike between personal freedom and public decency, and it seems like the weight of maintaining that balance falls heavily on the individual's ability to block any outside view.
Absolutely. Which leads to kind of a bigger question, doesn't it?
What's that?
Well, in today's world, with drones, Google Maps, houses packed closer together, how truly private can any outdoor space really be anymore? Something for you to think about. Welcome to the Deep Dive. Today, we're plunging into a stack of sources on a really high-stakes legal fight.
Yeah, one that went all the way up to the Supreme Court pretty quickly.
Exactly. Our mission here is to unpack this thing called the Department of Government Efficiency, DOGE.
Right. And it's controversial push to get access to millions of Americans' Social Security data. Very sensitive stuff.
We've got the legal briefs, court docs, news reports laid out. This deep dive is really for you to help cut through the noise.
And understand the stakes, when government efficiency goals bump up against these huge data systems and personal privacy.
Okay, let's jump in. So first off, what is this DOGE entity?
Okay, so DOGE was established pretty recently, January 2025.
Yeah.
It came from an executive order, 14148, under the Trump administration.
And the stated goal sounds reasonable enough. Modernize tech, cut waste and fraud.
That's the official line, yeah. Modernize government technology, root out waste. But, the name itself, DOGE, immediately jumps out from the sources.
It does. DOGE, you see mentions of potential links to figures like Elon Musk, Vivek, Ramaswamy.
And yes, the name referencing an internet meme, a cryptocurrency. It's quite a juxtaposition, given the serious mandate.
An unconventional name for sure.
And maybe an unconventional approach, too, because right away it was seeking, and the term used is full and prompt access to massive government data systems.
And specifically, the target was the Social Security Administration's data.
Primarily, yes. And we need to stress how sensitive that data is.
Yeah.
The SSA holds info on nearly everyone in the country.
We're not just talking names and addresses here.
No, absolutely not. It's Social Security numbers, obviously, but also detailed financial records, work history, even in some cases, medical and mental health information.
Wow.
Yeah. And the sources really emphasize this data has always been, fiercely protected. Laws like the Privacy Act of 1974 are key here.
People expect that data to be locked down.
Exactly. There's a strong public expectation of protection.
So, okay, you've got this new department, DOGE, with this meme name, wanting full access to super sensitive data. Predictably, this ended up in court.
Almost immediately. A coalition unions, advocacy groups filed suit in February 2025.
Their argument being
the DOGE demanding this kind of sweeping access just flat out violated existing privacy laws.
And the lower courts, initially, they sided with the privacy groups.
They did. First, a district court judge, Judge Hollander, issued a preliminary injunction. That was April 2025.
And she didn't mince words, did she?
Not at all. She called DOGE's request a fishing expedition, found it way too broad.
And she ordered them to actually delete data they'd already obtained.
Correct. Disgorge and delete was the phrase. She even suggested, look, maybe anonymized data could work for your goals. You don't need everything.
Then it went up to the appeals court.
The Fourth Circuit Court of Appeals. The government asked them to pause Hollander's injunction, but the full court, sitting on bank, refused. They let the restrictions stand.
So 2 federal courts basically said, whoa, hold on. This access seems excessive, maybe illegal, but that wasn't the end of it.
Nope. The government took it straight to the top, to the Supreme Court, asking for an emergency stay.
Using the emergency docket, sometimes called the shadow docket.
Exactly. And on June 6th, 2025, the Supreme Court granted that stay. It was reportedly a 6-3 vote, an unsigned order.
Okay, so SCOTUS steps in and basically says, pause those lower court rulings. What does that mean practically?
It means temporarily, at least, DOGE gets the access. They can access that sensitive SSA data right now, even while the main legal case is still being argued lower down.
And this is where the dissenters really raised the alarm bells.
Oh, absolutely. Justices Jackson, Sotomayor, and Kagan filed sharp dissents.
They weren't just disagreeing on legal interpretation. It sounded like they had fundamental concerns about the process and the impact.
Very much so. Justice Jackson, joined by the others on key points, really blasted the majority for granting unfettered access before the legality was even decided.
Highlighting the privacy risks.
Huge risks. They talked about grave privacy risks for millions of Americans, and they seriously questioned the government's claim of an emergency.
Like, did the government really show it would suffer irreparable harm if it had to wait for the normal appeals process?
That was exactly the dissenters' point. They felt the bar for emergency relief wasn't met, raising concerns about how the court uses these emergency powers.
Okay, so let's connect the dots here. What does this mean for you, the listener, right now?
Well, immediately it means this relatively new, somewhat opaque entity gets at least temporary access to your highly personal data. Data you probably assumed was very, very secure.
And bigger picture.
It throws that balance between government efficiency, which often relies on big data now and individual privacy rights, into really sharp relief. How do we manage that tension?
And there's an accountability angle too, right? You mentioned DOGE resisting transparency.
Yeah, the sources note other legal fights where DOGE apparently fought Freedom of Information Act or FOIA requests. So you have this picture emerging. An entity gaining significant power, accessing sensitive data, but maybe resisting public scrutiny.
It's important to remember the underlying legal fight isn't finished.
Not at all. It goes back to the lower courts to be argued on the merits.
But the Supreme Court's emergency ruling is a big deal. It allows access now that multiple judges and 3 justices found deeply problematic.
Precisely. It creates a sort of fait accompli, at least for the time being.
So wrapping up this deep dive, it really reveals this complex, tangled technology, vast amounts of data, legal challenges, efficiency versus privacy.
And while the courts continue their work, the highest court's temporary green light allows access that many find worrying.
Which leaves us, and you, with a question to chew on. As governments push harder for data-driven efficiency, what safeguards do we actually need for our most sensitive information?
And maybe, how do we hold these powerful entities, especially those operating perhaps outside the usual lines, truly accountable? Something to think about.